Joe Hoelscher.
Hi, I'm Marco Cepeda.
With another installment of HGC TV. Today, we're reviewing movie clips of lawyers from the silver screen to critique their performances. If you like this segment or some of our other content, don't forget to subscribe or let us know how we're doing in the comments section.
Okay, so right now I'm going to check out a clip from Big Daddy.
You're wrong, Dad. You can be scared that I might get pickpocketed in a bad neighborhood or I might break my leg skiing, but don't be scared about me being a dad because I will not fail at that.
Well, this will never happen in court. Obviously, they're just kind of talking back and forth. I think his dad's not even one of the lawyers in this, so there's, generally when you have somebody on the stand, you're asking if it's direct, you have to ask them certain questions and they have to respond. If it's on cross, you should only ask leading questions. You can't ask leading questions on direct. This is just kind of a conversation. So this would never happen in real life. Although it might be helpful sometimes, but this would never happen.
I can't. I love this kid too much. I love him as much as you love me, Dad. And I'm gonna give him advice, and I'm gonna guide him, and I'm gonna be there for him whenever he needs me. I'll fly to New York to be at his court case, even if I disagree with why he's there in the first place.
So you would want your client to say all this on the stand, but again, you'd have to ask him these questions and kind of get him to start talking about these certain things. I don't know any judge that just let this happen, where, they just go back and forth like this, but it is heartwarming, I guess.
Hello, Dad? Yeah, I just wanted to say I love you.
Hi, Mom. Could you put down the phone for a sec? Can I borrow that?
Obviously a judge isn't going to let everybody start calling during a hearing or a session, start using their phones, so it's a comedy, though.
My son deserves this kid.
So yeah, the last clip, they had the little kid there. That's also a big no-no. Judges don't really like kids in court. Under certain motions, if it's a child custody case, a judge could talk to the child in chambers if requested by a party. But yeah, generally they're not just going to be wandering around the courtroom. So that just wouldn't happen.
Alright, so this is from My Cousin Vinny, which is one of my favorite movies because I had a crush on Marissa Tomei, but also my uncle is in this movie. He plays the sheriff. Bruce McGill is his actual name. So I'm going to start with this scene, and I can't wait to see which one it is.
Sit down and stay there until you're told to leave.
Your Honor, Ms. Vito's expertise is in general automotive knowledge. It is in this area that her testimony will be applicable. Now, if Mr. Trotter wishes to voir dire a witness as to the extent...
That's a big problem throughout the South, and especially in Texas. We don't say voir dire, the French. We say voir dire, and it means that we get to cross-examine the witness, which is in fact what he was doing. So the problem with this scene is they've done things in the wrong order. But this scene is actually used to train lawyers on how to properly prove up a witness and get them qualified to testify. So aside from the fact that he's pronouncing things like a Yankee and Trotter was already cross-examining her, this is exactly what should be happening.
Question, it's impossible to answer.
Impossible because you don't know the answer.
Nobody could answer that question.
Your Honor, I move to disqualify Ms. Vito as an expert witness.
Can you answer the question?
No, it is a trick question.
Why is it a trick question?
Watch this.
Because Chevy didn't make a 327 in 55. The 327 didn't come out till 62. And it wasn't offered in the Bel Air with a 4-barrel carb till 64. However, in 1964, the correct ignition timing would be 4 degrees before top dead center.
Well, she's acceptable.
The look on that lawyer's face is one of the greatest achievements a lawyer ever gets. I love it. I love it. It's a good scene. when we're prepping our clients, one of the biggest things that we need in a lot of cases is a good expert who can really speak to the issues of a case and be persuasive. And the big lesson that this scene is used to teach lawyers is your experts don't have to be some fancy trained expert. It just has to be somebody who has specialized knowledge and really gets their field. And Miss Vito did. Also, Marissa Tomei. So.
It's one of the most famous lawyer clips out there, and it's from To Kill a Mockingbird and Atticus Finch, when I believe he's cross-examining the accuser.
Tom, will you stand up, please? Let Miss Mayella have a good long look at you. Tom, will you catch this, please? Thank you. Now then, this time, will you please catch it with your left hand?
I can't, sir.
Why can't you?
I can't use my left hand at all. I got it caught in a cotton gin when I was 12 years old.
So there's a couple of issues here. Number one is that generally when you're doing cross-examination, you're seated down and you can't just be standing up and walking around the person you're cross-examining. And also he's asking somebody questions who's not on the stand, so his own client. So to make the point he's about to prove, he need to get that through evidence, through his testimony on the stand or somebody who had knowledge of it. He's basically has somebody else on the stand, he's asking his client questions, so that wouldn't happen in real life.
You didn't say that he sneaked up behind you and knocked you out cold, but that you turned around and there he was. Do you want to tell us what really happened?
I got something to say. And then I ain't gonna say no more. He took advantage of me.
He probably would have tried to object to, I guess non-responsive. She's not answering the question and she's going based on some narrative here. He could object to that as well. The questions he asked were appropriate, I think, and they're effective because he's trying to prove that he's not capable of doing what, she's claiming he's done. So that's, other than that though, I mean, it's not a bad scene.
This clip is from Legally Blonde. It's one of the few scenes I've ever remembered from this movie because it's another great cross-examination of a witness by an attorney, relying on her expertise and knowledge of the case. We learn about perms.
What had you done earlier that day? I got up, got a latte, went to the gym, got a perm, and came home.
Well, you got in the shower?
I believe the witness has made it clear that she was in the shower.
It's called a comment on the evidence by the judge. It's absolutely inadmissible, it's objectionable, and in many cases, in fact most cases, it's reason for a mistrial. But of course the message we're supposed to get from the piece is that even somebody like a young lawyer can stand up to the system, including a snarky judge. So other than making opposing counsel look sad, standing up to a snarky judge is another one of my favorite things to do in trial.
You know, a girl in my sorority, Tracy Marcinko, got a perm once. We all tried to talk her out of it. Curls weren't a good look for her. She didn't have your bone structure. Oh. But thankfully, that same day, she entered the Beta Delta Pi wet t-shirt contest where she was completely hosed down from head to toe.
Objection. Why is this relevant?
Oh, I have a point, I promise.
That's a solid objection because this is not relevant at this stage. During cross-examination, attorneys are only supposed to ask questions, and what we say isn't evidence, only the answers are evidence. So statements like she's making are called sidebar and inadmissible. However, good defense attorneys know how to create the drama that she's trying to create.
Chutney, why is it that Tracy Marcinko's curls were ruined when she got hosed down?
Because they got wet?
Exactly. Because isn't it the first cardinal rule of perm maintenance that you're forbidden to wet your hair for at least 24 hours after getting a perm, at the risk of deactivating the ammonium thioglycolate?
Yes. And wouldn't somebody who's had, say, 30 perms before in their life be well aware of this rule? And if, in fact, you weren't washing your hair, as I suspect you weren't because your curls are still intact, wouldn't you have heard the gunshot? And if, in fact, you had heard the gunshot, Brooke Wyndham wouldn't have had time to hide the gun before you got downstairs, which would mean that you would have had to have found Mrs. Wyndham with a gun in her hand to make your story plausible. Isn't that right?
Now, we all wish we could just hammer a witness with questions like this to build the dramatic moment and break them, but we're not allowed to. And in fact, we get yelled at for talking over the court reporter or the witness or the judge, because we have to have a clean record and the witness has to be allowed to answer each question, which is why we often train our clients to ask a lawyer when they are having difficulty with a question just to repeat the question or rephrase it, because it breaks up the role, and a lot of lawyers, when they're in that moment, can't go back and remember what they just asked. But here, it's TV, she gets to hammer her, and we get a result.
How would you feel if your father married someone who was your age? You, however, had time to hide the gun, didn't you, Chutney? After you shot your father. I didn't mean to shoot him. I thought it was you walking through the door.
Order, order. Order.
Oh my God.
Oh my God. Oh my God.
I love that there was justice done here. You know, I actually broke a witness on the stand one time in a self-defense case so badly that the jury asked for the alleged victim in the case to be arrested, and the prosecutors refused, as did law enforcement. But, well, we don't always get the trauma, we don't always get justice. It is a lot of fun to cross-examine, and that was a fun moment. You know, it's one of the most fun moments in a lawyer's career, is to get that person who's challenging you, use their own words against them, and prove that they are full of crap. But it's also why we have to prepare our clients so they don't fall into these types of traps. But hey, you know, it's legally blonde. It's not legal in any capacity. It's everything that we see about lawyers on TV, just steamrolling somebody into that moment where they snap. And there's a lot more that goes into it than that, but you know, it's always nice for a baby lawyer to get a big win.
I'm about to review a clip from a civil action. I'm not very familiar with this movie, but I know it had to do with certain insurance claim that was being done.
A dead plaintiff is rarely worth as much as a living, severely maimed plaintiff. However, if it's a long, agonizing death, as opposed to a quick drowning or car wreck, the value can rise considerably.
What he's getting at right there is basically a couple of things. The more egregious the negligence is in causing somebody's death or something like that, the more somebody can get in punitive damages. That's not actual damages. Actual damages is what you can calculate, but you know, through, like what he said, a man in his prime being struck down, what he would have made in the remaining years of his life, his working years, what he would have made, those are actual damages. But punitive is if it's something that, in addition to actual damages, something that's so egregious that, you know, they need to be punished.
This court is now in session. The Honorable Constance Mullen presiding.
Generally, you have all the parties seated first, and then they bring in the jury. So you rise up, and then they bring in the jury. So I think this is odd that they're coming in. I mean, I could see why he's doing it for effect, but usually they have all the parties, the plaintiff and the defendant there, before the jury's brought in.
Carney versus Massachusetts General Hospital, case number 812725. Attorneys, please state your appearance.
Randolph Woodside, Mass General.
Greg Monk, Massachusetts General Hospital.
So he's sending them kind of informal settlement offers. You could, up until a verdict, you can really settle the case. So at this point, you know, assuming they haven't, you know, closed or anything like that, it's up to the jury. They could still settle this since there's not been a verdict. So that's not something that's completely uncommon. Maybe writing them on sticky notes is, and you kind of get this resolved beforehand, but you could still settle at this point.
Your Honor, if it please the court.
I don't think somebody would say please if they're making that offer, but now this isn't common. I don't do a lot of PI, but you know, there would be a settlement right I don't think it's very common to have a settlement right before you begin opening statements. I don't think that's realistic, though it is possible.
The next clip is Primal Fear, which I've not seen, but it looks like it has Edward Norton in it, and I like him, so I hope he doesn't disappoint me as an attorney.
Even though he made you and your girlfriend perform demeaning sexual acts for his own gratification.
Unfortunately, he's the witness, and it's not going well.
No, you don't understand. There was no other way for him to cast out his own demons. He needed it.
He needed to get off.
That's argumentative. That is not a question. She's not asking something, and so it's an impermissible sidebar or argumentative, which is another objection. Also, she didn't take her answer, which is one of the things a lot of our clients don't get when we're cross-examining witnesses, is sometimes the witness starts to say something that we don't like, and we just sit there, and it's because if it's in response to our question and not non-responsive, that is just on a tangent, we have to take our answer. That's also a fun objection to make, though, when some other lawyer's over there getting a bad answer and tries to cut the witness off. You get to stand up and go, "Oh no, Judge. He has to take his answer and let the witness finish." And then you stare at the jury and you smile the whole time that witness says whatever it is that lawyer was trying to hide. But yes, this seems like kind of a screwed up movie. Straight into the child abuse, apparently.
To perform like a circus animal. That was your function in his life.
No.
Oh, Mr. Stampler, I'm going to ask you straight because I am tired. And I've had just about all I can take of this sordidness. And I want to go home. And I want to wash my hands. And I want to forget all about you and Archbishop Rush.
Man, that's really out of line. That's so objectionable. It's inflaming the jury. It's sidebar. It's just rude. It's not even sympathetic. It's a bad jury argument. And I'm not sure why the judge hasn't yelled at her yet.
You and your girlfriend and others to perform sexual acts while he watched, yes or no?
Yes, he did,
yes,
but...
Yes, he forced you. He forced you using a threat of expulsion from Savior House and a life on the street with no heat and no water and no food.
Yeah, this is a bad one. Okay, so that set of questions, the technical objection is multifarious. She's asking multiple questions in one question. And so the problem with a multifarious question is, she's making all of these assertions, one after the other. When the witness finally answers, you don't know what he's agreeing to or denying. It also puts a witness in a position where they feel like they would agree to some things and not others, and so they can't answer it, and it creates a terrible record. Also, she's losing emotional control, which psychologically makes her look like she's losing. It doesn't actually make her look like she's winning, although these are like the dramatic scenes that we see in movies and TV all the time. In real life, when people see someone like that, they feel uncomfortable. And when they see somebody losing control or getting angry, they perceive them as losing. There's a lot that's wrong with that one, and then there should be objections. So far, I don't know, like the defense attorney apparently, or whoever the opposing counsel is, seems to be pretty terrible.
Another face of a man that we all thought we knew.
No.
Do you know what I would do if someone did that to me? I would kill him.
That's when the court reporter starts yelling. So, as attorneys who handle difficult cases and do a lot of trial work, we're used to having people fuss at us, and sometimes we provoke it intentionally. It's part of the process. But the one person that you never argue with is the court reporter. Because the court reporter is typing everything down and keeping a record. And if you need to prove what was said by yourself or somebody else, you need that record. And the court reporter can't type down two people at the same time. Only one at the same time. So court reporters, when lawyers talk over a witness's answers like that, will usually say something. Sometimes they're polite about it. Most of the time, it's happened so often and they've learned from the past that being polite doesn't slow a lawyer down, that they just yell at us. And it's kind of embarrassing because they're yelling at you right in the middle, usually, of some key part, some really contentious moment, which is why people start talking over each other.
But that's me.
Not a question.
No further questions, Your Honor.
Where the hell do you think you're going?
Excuse me?
Hey, you look at me when I'm talking to you, you bitch. Mrs. Stampler. Fuck you, lady. Come here.
Bailiff!
Come here, you want to play rough? Let's play rough. Hey, come on. Back off. Hey, back off. Hey, come on.
This is my favorite part of the scene, actually, because I think she deserves to get strangled slightly for being such a terrible lawyer. And everybody else deserves to be in the same problem because they were terrible judges, witnesses, and lawyers. So I'm actually feeling like this is the moment of justice, and I'm hoping something bad happens to her.
I'm an asshole. You see if I don't break her fucking neck.
Roy, come here. I gotta talk.
Fuck you, Marty. I am walking out of here now. Slow.
That was a disappointment for me. You never see people lose it like that. You know, kind of the Perry Mason moment. It's exceedingly rare, and it doesn't normally actually happen during cross-examination, in my experience. It usually happens when the judge is kind of getting preachy during sentencing, or when they're telling somebody why they're ruling against them, and people take it personally. I did see a guy in chains one time climb up the bench to get a judge, and she was cold, man. She just stared at him. It doesn't develop like that. There's no giant crowd that comes in. There's no group fight. There's some bailiffs with tasers, guns, and batons, and they just throw people straight to the ground because you're in court, and they're not going to let anything bad happen in court. You know, yeah, there was nothing good about that scene. There was nothing done correctly. There were a lot of things that other lawyers should have done that they didn't do, and I don't know why the bailiff was in the back of the courtroom when there was a witness on the stand, because normally they're Johnny on the spot in position to go jump somebody who might get out of control. Thanks for watching another episode of HGC TV. If you liked this episode and want to get more of our content in the future, don't forget to subscribe. And if you have feedback for us, don't forget to comment. Again, I'm Joe Hoelscher with HOELSCHER GEBBIA CEPEDA, PLLC. Thanks for watching.